Hello, everyone, and welcome to Untangling the Technical, Fraser and Dieter's podcast, in which we take a look at complex topics to break them down for business people navigating today's ever-changing tax and regulatory environment. I'm Adele Erdman, and today we're excited to have with us John Korn, the leader of Fraser and Dieter's state and local tax practice. Good morning, John.
Good morning, Adele. It's very nice to be here with you today.
All right. Well, we wanted to get together with you today to talk about the Supreme Court case that's having a big impact on companies who sell products and services across multiple state lines. Could you give us a little bit of background on the big Wayfair Supreme Court case?
Yes, in the Wayfair case, the U.S. Supreme Court considered the constitutionality of a South Dakota law that required certain remote sellers to register for, collect, and remit South Dakota sales tax. And under their law, a remote seller has Nexus with South Dakota if the seller in the current or previous calendar year had gross revenue from sales of taxable goods and services delivered into the state exceeding $100,000, or the seller sold taxable goods and services for delivery into the state in 200 or more specific transactions.
Wow, so they were looking at this year and the prior year.
Yes, the prior year was just a gauge to determine if you had Nexus, but keep in mind this decision has the sales tax responsibility for the taxpayer just going prospectively. It will not be a retroactive look back.
Okay, so it's just going forward.
Going
okay.
forward. Mm-hmm.
All right, so this happened back in the summer. And I know there was a lot of back and forth about, this is South Dakota. How will the other states react? And now that we're recording, sitting here in the middle of October, how have the states reacted?
Well, some states had already implemented some economic nexus policies. And let me just kind of describe what the economic nexus policy is. Earlier, the Commerce Clause of the U.S. Constitution requires a seller to have substantial nexus with the state before the state can require the seller to collect and remit sales and use tax. And historically, under the precedent affirmed in the 1992 Supreme Court of Quill Corporation versus North Dakota, nexus depended on whether the seller had physical presence in the state. The presence could be through the company's activities or boundary of this standard by asserting click-through nexus and affiliate nexus. So now economic nexus policies like South Dakota's law and Wayfair stretch it further still in states asserting the jurisdiction to impose sales tax collection responsibilities on companies that meet certain sales thresholds. So in other words, you cannot even be in state or have any physical presence in state, but you're just selling into that state's marketplace. That could give you nexus if you meet these nexus thresholds.
Wow, that's interesting that it was previously a North Dakota court case and now it's a South Dakota court case. It sounds like the Dakotas are looking for tax revenue, huh?
That's correct.
Yeah, interesting. So you were talking about previously it was in the brick and mortar world that Nexus was based on having a presence, and now that's no longer how a lot of companies do business. So could you just back up a little bit and tell us a little bit about the concept of Nexus?
Well, Nexus is a connection sufficient enough for a state to assert tax over a taxpayer. We look at it a lot of times that if you've got regular and systematic activities within a state, which is either property, payroll, and gross receipts or sales, and that's on a regular and systematic basis, that would give you nexus. This changes a little bit because now it could be temporary and sporadic, but you've got sales and the sales are constant in the state. Now you'd have nexus under this new Supreme Court decision.
Interesting. Well, so it's a big update. So the states see opportunity. Could you give us some examples of how different states are defining nexus?
Well, some states are taking the same criteria that the Wayfair decision had with the $100,000 in sales or the 200 transactions. Other states had already implemented nexus policies, and it could be anything from $500,000 and no transaction limit, or it could have been $250,000 and 200 transactions. Or it could have been that you could comply with the transaction criteria, revenue criteria, or voluntarily provide a list of all the sales that you made into the state to the Department of Revenue so that they can send notices to all these people that purchased in these states that they owe use tax to the states. So you've got kind of a mixed bag from state to state, but I think predominantly we're going to see most of the states adopt the South Dakota threshold criteria.
And just for my clarification as a non-accountant and non-business owner, you could have either the $100,000 or the number of transactions, and either one of those triggers owing the tax.
That is correct.
Okay.
And most of these policies, some were implemented in September of this year. Some will go into effect in October this year. And the latest we're seeing is a lot of them are going into effect on 1/1/19.
So what advice do you have for a company that is looking at all this and all these moving parts?
Well, the first advice is you got to look if your sales are to an end user or if they're wholesales. In other words, you're selling to a wholesaler, because in that case you would get an exemption certificate from the purchaser, and that relieves you the obligation of collecting the tax. So it's a matter of understanding the nature of your sales in each of these states. Then I would go back and look at the revenue thresholds for the prior 12 months and determine how that fits with a lot of the rules that have already been implemented, along with the transaction threshold, to see if you're going to have to comply prospectively with these new economic nexus policies.
Okay, wow, it sounds pretty complicated and like a pretty good year to check in with your tax advisors if you're selling across states. Fraser and Dieter has been publishing updates on our website, and will continue to do that as this situation evolves. John, I wanted to thank you so much and mention that any of our listeners who want to reach out to John to pick his brain a bit and understand this better can find John's contact information on our website under our state and local tax advisory practice. So thank you, John, for joining us for this edition of Untangling the Technical.
Thank you very much. It was a pleasure being here.
Thanks for listening to one of Fraser and Dieter's branded podcasts. To learn more, connect with us on LinkedIn or visit us at FraserDieter.com, and be sure to subscribe so you never miss an episode.